The final matter to come before us this morning is Yulanda McDade versus Tom Morris et al. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve some time, please let me know, as I'm keeping the clock for the court this morning. We've read the briefs and we are ready to proceed when you are.
Thank you, Your Honors. Kurt Anderson for non-party appellant State Farm, along with my colleague Greg Collins. Your Honor, I would like to reserve 5 minutes for rebuttal. Your Honors, the nature of the subpoenas that were issued to State Farm on their face demonstrate why they are both irrelevant and protected, seek protected information. They are irrelevant because they have nothing to do with the things that Yulanda McDade needs to prove in order to get a judgment against the defendant, Tom Morris. They seek information that is not just limited to Dr. Flores' treatment of Yulanda McDade. In fact, they don't really care about Yulanda McDade's treatment. They don't even seek information that is just limited to all treatments to third-party claimants, which Yulanda McDade is. They don't even limit themselves just to treatment of first-party claimants, insureds of State Farm who may be making claims based on treatment by Dr. Flores. They ask for all information about any policies or procedures for claim settlement or claim litigation relating to any treatment by first or third-party claimants, not only who have been treated by Dr. Flores and by his corporation, Akron Chiropractic, but also any of those type of claimants who have been treated by any of the franchise or subsidiary corporations of Chiropractic Strategies, which is Dr. Flores' parent company.
I noticed in the brief that your client did not raise a claim. Well, I guess you did say that it was burdensome, but didn't really talk in terms of the number of pages and files and so on and so forth. So it wasn't the typical burdensome claim that we get where a request is just going to take hours and hours and days and weeks and fill boxes. I didn't get the impression that that was really the objection.
The objection is not necessarily, although it could be, about the volume of information. The most important objection is that it's completely irrelevant. We're a non-party. Non-parties are not to be dragged into outside litigation unless, and it's right in Rule 45, unless there is a substantial need for that information, meaning not only is it plausibly, hypothetically relevant, but there's a need for it, and that this is the least burdensome way of getting it. They haven't shown that it is necessary to their case. In fact, we are arguing that it is not, and that this is not the least burdensome way of getting it. But more importantly, what this is really just a pretext for getting into the claim settlement strategies and the claim litigation strategies.
Well, to that end, the opposing brief indicates, and I imagine we'll have this in the record, that when Dr. Flores was examined, that, I don't know, the term 90% or 95% of the questions asked of him dealt with these very issues.
The questions that were asked of him dealt basically with office procedures. They asked him about his advertising, they asked about his client solicitation, about scheduling clients, about tracking the data, collecting the number that are related to plaintiffs or workers' comp cases. So yes, the questioning was not necessarily limited or focused specifically on Yulanda McDade's treatment. But the issue that they claim that this is directed to is to explain why Dr. Flores referred her to counsel. Well, first of all, Dr. Flores answered that question. He explained, I saw that she was coming here as the result of a car accident with a State Farm insured. And he claimed to have had some prior bad dealings with State Farm, and he knew that he was going to be in for a fight, or that she was, and that bills weren't going to get paid. And so he referred her to counsel. On its face, he's already answered the question. They don't need more information. And in fact, the information that they're seeking isn't information that Dr. Flores would have had or relied on in order to refer McDade to counsel. They're going beyond that. This is not information that Dr. Flores had or needed in order to refer her to counsel. But as far as the referral to counsel goes, the information that he had, his own personal motivation, that's all the information they need to answer that question. And in fact, they've never...
Well, that presumes that that'll be the end of it, but, you know,
Well,
if this litigation and the direction of the energy that's being expended is any indication of what will happen at trial, my suspicion is that having the doctor just say that is not going to be the end of the inquiry.
well, we would expect that the judge would limit that because, number one, the case law that they are using to say that this is admissible evidence is not even Ohio case law. Ohio courts have not made a decision as to whether or not the explanation for referral to counsel that involves insurance is admissible because it raises the question of prejudice by introducing evidence of insurance. Those aren't Ohio cases. That issue has not even been decided as being admissible. Nevertheless, those cases that they're relying on to say that it is even a plausible argument limit the amount of information about insurance that can be made available, and the explanation goes as far as saying what the motivation was and goes no further. The reason that we are expending such effort in fighting this is because of the second issue. By definition, the information that is being sought is about policies and procedures where supposedly State Farm has said, we will not settle your claim, regardless of whether you're a first party or a third party claimant. We will not settle your claim if you had treatment by Dr. Flores or chiropractic strategies. We will not settle that claim. You must litigate it. You must get a judgment against us or against our insured in order for us to pay your claim. Well, that, first of all, that's their prerogative. With third-party claims, especially like Yulanda and McDade, we have no obligation whatsoever to pay them a cent until they get a judgment. Now, for economic reasons, defendants may choose to settle claims. But if, in fact, this policy is, as they say, we refuse to settle any claims, you must litigate them, then by definition, these policies and procedures are about claims that State Farm has chosen to litigate. By definition, then, the policies and the procedures, the posture it has taken about litigation is in anticipation of litigation. We anticipate, we plan ahead of time. We're going to litigate according to them. We're going to litigate these claims. If Dr. Flores is the treating physician, according to them, State Farm apparently has him on a blacklist, and we don't buy the fact that he's a legitimate, upstanding chiropractor and, whatever. That's their argument, right? But accepting that on its face, even if it's true, if in fact State Farm has chosen to say, this is our policy, we won't pay, you must get a judgment, then by definition, those policies, procedures, strategies, whatever they are about claims that State Farm has chosen to litigate. For them to get into all of that for us is to get into our preparation for litigation.
Explain to us how this is a final appealable order in light of the fact that the trial court explicitly disallowed or explicitly excluded from the need for production any privileged information.
Right, because, and that answers two questions, really. One, which is, why is it a final appealable order? The other, which is, why isn't that protection, that in-camera inspection, a sufficient protection? Number one, because it completely skips the threshold question of relevance. If it is irrelevant, it is unduly burdensome. There's no need to even make us collect all the documents, identify all the documents, generate privilege logs, produce all of that to opposing counsel and to the court, have a hearing and argue in front of the court about what each document is or to the scope of its protection. we shouldn't even have to go through all that if, in fact, this is irrelevant. The rule says that once there is an objection based on undue privilege or a couple of other objections that we also raised, once there is an objection to that, the burden is on them to demonstrate that it is, in fact, substantially necessary and that this is the least obtrusive means of getting that information. So not only does it skip the threshold question of relevance, but it also shifts the burden from them, which is under the rule. They have the burden of proving relevance and no other way of getting it. And it makes us prove, as they've argued extensively in their brief, that we have to demonstrate the privilege applying to any of these particular documents. The presumption is that it's not privileged. The presumption really, though, is that it's not relevant. They are the ones who need to demonstrate that. But our argument as to privilege is that on its face, the category of documents that they are seeking is, in fact, by definition, privileged or protected as preparation for litigation. If we have...
reaching into your rebuttal time, I just want to let you know you may continue. I don't know if you had...
I'll be happy to answer any further questions.
Thank you.
Great, thank you.
May it please the court. Chris Van Blargen, and along with John Reagan and Louis Zarnis, I have the privilege of representing the plaintiff's appellee, Yulanda McDade, in this case. We're here because of an order that was issued on July 1st of 2014, which did not require the appellants in this particular case to produce any particular documents, but rather required them to comply with Civil Rule 45D4. In particular, to show or give some proof that the documents that they are claiming are privileged do meet that requirement.
But isn't there a part of the subpoena that is for a deposition of their staff members? Not just a records deposition, is it?
Correct. No, there's also subpoenas. And again, the question is, there's no order that as part of those depositions, those individuals who are going to be deposed will be required to disclose privileged information. They can assert the privilege at the deposition or by way of a motion for protective order prior to those depositions, and pointing out what particular pieces of information are actually protected under, or what they're claiming is protected. The problem being is that because there was no order requiring disclosure of privileged information, this is not a final appealable order. The case law, if this would have been a party being subpoenaed in the case, is clear. Whether or not information is relevant, whether or not information is unduly burdensome to produce, the court has discretion, the trial court has discretion to make that order, and those orders cannot be appealed until after the trial's over. What happens here is that the appellants are trying to distinguish between parties and non-parties. And of course, there is additional protections afforded to non-parties in discovery proceedings. But first, there's a question of whether that extends to people who actually, or parties who actually have an interest in litigation, although are not named, versus true strangers to the litigation. In addition, there's also questions of whether a non-party who interjects themselves within the litigation itself through retention of counsel, through decision-making with respect to whether or not this is going to go to trial, should have that same protection afforded. In addition to that, alternatively, even if this is a final appealable order, we do not believe the trial court abused its discretion in issuing the order requiring them to comply with Civil Rule 45 and disregarding the objections to the evidence on the grounds of burdensome, irrelevant, because there wasn't any information produced which allowed the court to make a decision of whether or not there was any validity to those arguments. Just general descriptions of the categories of documents that were being requested. And again, the case law is clear with respect to parties that a trial court has broad discretion in ordering discovery, and if it makes a decision based on relevance or admissibility and whether it should be discovered, that is not a final appealable order that would come before this court. And in fact, allowing those types of order would wreak chaos with the trial court's case management and with the case proceeding, because it would allow any party or non-party to raise objections to admissibility without supporting those arguments, and then have the case delayed for a year while it went to the appellate courts. That's the reason why these orders are not supposed to be appealable and brought up to the court. They're matters of discretion that can usually be corrected later in the proceedings, particularly where the party who is objecting has an interest in the case, has control over the case, such as State Farm and individual non-parties who are appealing it here. There is some authority which allows non-parties to appeal. I think that is not a unanimous decision among the appellate court districts, and it's dangerous for a couple of reasons, because it basically gives non-parties the ability to control the litigation and threaten the appeal to avoid producing any documentation. We had an explanation here that there has to be a substantial need for the discovery, but that's the second step in the analysis of whether or not it should be ordered from non-parties. There has to be a showing or an argument of the specific factors that allow protection, such as burden, privilege, etc. And there has to be at least a minimal level of proof that those are actually valid points. In this particular case, there was actually nothing to show that it was burdensome, other than the fact that State Farm has decided that it's irrelevant. That decision should actually be left to the trial court in the first instance, and not subject to an appeal, immediate appeal. It's something that can be dealt with later in proceedings. The other problem is this leads to premature appeals. In this particular case, we have some issues. They're arguing that the information is not relevant. The trial court has not had an opportunity to take a look at it through in-camera inspection or through a privilege log, and this court is faced with a blank record with respect to what documents are actually in existence and whether or not they are relevant to the case. That, I think, is part of State Farm's strategy in this particular case of appealing this issue immediately, because it doesn't want the court to know what's in those records. It's a great way to avoid actually looking at the particular documents at issue and arguing to the general proposition that insurance information shouldn't be injected into a case. Another problem in this particular case and why it's premature is that the court has not ruled on whether or not the deposition transcript of Dr. Flores, which in fact was exclusively on his business practices, not anything to do with treatment, is going to be allowed into a trial. If the court ultimately rules that information does not come in, the discovery requests are irrelevant. There's no need for the discovery, because at that point we're no longer talking about Dr. Flores' business practices. We're talking about the merits of the case, the medical treatment. Assuming that the court's order is a final appealable order, we respectfully submit that the court did not abuse its discretion allowing the discovery. First, again, it did not require that the appellants in this particular case produce any privileged information. It expressly said that was not required. All they had to do was comply with civil rules. With respect to any information that they would be required to produce because it was not privileged, the court did not have any information with respect to what particular documents they were complaining about and which would be burdensome and how much burden it would actually impose on them. In addition, set forth in the brief without going through the full facts of it, there is a pattern of treating Akron Square and other medical providers and state-by insurance companies as individuals who are open to attack and trying the case through ad hominem attacks rather than actually looking at the medical facts of the case. And we had a case before the court last year which involved Grange and Akron Square private practice, which counsel frankly admitted that it's much easier to engage in ad hominem attacks than to engage their own medical professionals. It's much more feasible to do it that way. And that was decided Chambers versus Lee just last October.
But isn't that, so I guess the end result is the way that they make decisions in a litigation file or in anticipation of it becoming a litigation file is completely up to them. It has nothing to do with...
Our position has always been that decisions regarding how individuals get to counsel, whether it's the plaintiff or the defendant, are irrelevant to the case. And we should be trying the case on the merits of the case, the medical treatment, not how people get to counsel. They were the ones who crossed the line with Dr. Flores and spent an hour deposing him about his business practices, how he referred patients to counsel, and what those situations were. The only way we can effectively counter and rebut those arguments at trial is by showing that this is not just happening on this side of the ledger. It's also happening with defense counsel. There is a strategy. As we discussed, Dr. Floros explained that, yes, he refers State Farm patients to counsel, and he has a reason for that because they don't pay his bills. They didn't pay his bill in this case. They paid the emergency room, but refused to pay his bill. Of course, they're not going to just let that go. They're going to argue at trial that, yes, that's his excuse for referring patients to counsel. It's really something more. If there is evidence that this is the strategy, this is their business decision, the jury should be able to know that. It's either keep this information out, try the case on its merits, or if we're going to let this information in, it should be open to everyone. The jury should see all the facts in the case.
I guess what I'm struggling with is how this comes out at trial. Is it an effort to discredit the treatment given?
Exactly.
Not necessarily whether or not someone decided to file a lawsuit for their injuries?
Correct. The idea, and I think Range had did this in the prior case, is that in a small case like this, it's easier to attack the treating physician, to attack the credibility of the case, than to actually bring in their own medical physician, have to pay his fees, and go forward with actually proving the medical facts of the case. So this is a strategy. This is not just an isolated incident that's part of the case. It's an overall strategy of how to try these cases. Unless the court has any other questions, we would ask that the case be dismissed for lack of appellate jurisdiction, or alternatively, that the court enter a decision that the court did not, trial court did not abuse its discretion or remand. Thank you.
Thank you, Your Honors. There's absolutely no need for them to introduce evidence of insurance or to introduce why State Farm is making some kind of a judgment about how to proceed with strategy. The doctor is a witness. He is a treating physician. He's an expert. He's going to make an expert opinion as to proximate cause and the reasonableness and necessity of his own treatment. So his own credibility is always on the line. Every witness's credibility is open to attack. Why they need State Farm's information in order to validate the credibility of their own witness, he should be able to stand on his own 2 feet and to say, no, this is what I did, this is what I treated, this is why she needed it, and so forth. If State Farm wants to make an attack on his credibility, it's perfectly entitled to do so. But if we're going to allow deponents to start saying, why do you think my expert is a liar? I want to investigate your investigation of my witness. That is preparation for litigation. That is exactly why State Farm is so defensive about this effort to get into our litigation strategy. The other issue is that this is a final appealable order because we have no other remedy to be able to seek redress before being dragged into court and being made to produce documents. He just said, first produce the documents, then the court will decide whether they're relevant or not. The court needs to review.
referred to in camera, which
Excuse me?
is not unusual to have documents that are alleged to be privileged, produced in camera for the court to decide.
That's focusing on the privilege question. If in fact we're going to decide what's privileged and what's not. But that assumes that we've answered the first question, that there is in fact a substantial need and that this is the least obtrusive means. Rule 45 is very clear. If it is unduly burdensome, and irrelevance is one category of unduly burdensome. If it's irrelevant, it's unduly burdensome, by definition. If it is irrelevant, then it must, the subpoena must be quashed unless they prove that they have substantial need and that there is no less burdensome means of getting it. So to say, no, first you produce it, then the court can review it and decide if it's relevant or not. No, they have the burden of showing why they need this. Not to go sifting through it to say, oh, here's something maybe that we can use. Well, why put us through through all of the hassle of getting it in the first place? And to go back to the question that we left off with you, the order of in-camera review has no protection whatsoever for the deponents. We can't submit the deponents to an in-camera review So our employees are being subjected to a deposition that has no opportunity for judicial review and screening in the first place. But even so, if the category of information that they are seeking is irrelevant and they can't show that they have a substantial need for it and that it's the least burdensome means of getting it, then it never gets any further if they can't carry that burden. And they've agreed. Dr. Floros explained why he referred her to counsel. He gave that answer. That's as far as it needs to go. And the trial court can decide whether or not even to let that answer in because it injects insurance. But it shouldn't go any further than that, because any further discussion of insurance and that somehow State Farm is a de facto party, which I would disagree with on the case law anyways. The evidence of insurance not only is inadmissible, but the involvement of insurance companies in the litigation between plaintiffs and tortfeasors were supposed to not be a visible party anyways. They can't even bring a claim against us unless they get a judgment, and then they proceed on a supplemental complaint under the statute. To say that we're a de facto party is going to open up a huge can of worms. But the fact...
And you've reached the
Okay.
end of your allotted time.
Thank you very much.
For your presentations today, the court will take the matter under advisement and issue a written decision, which will be mailed to both sides and posted on our website. Thank you, gentlemen.
Thank you.